itself has warned itself against wholesomely applying those decisions to parliamentary elections. The Supreme Court itself. Now, this is the case of Mukasa Anthony Harris. Mukasa Anthony Harris versus Dr. Philip. Supreme Court itself that made the decision is telling you, please go slow when you come to this in 7. My Lord, this decision has no page, but I'm going to do this. It's a new matter. It's not there. It's a new case. Let me read for you what their lordship said in the Supreme Court. Learned counsel relied on the reasoning of my learned brother Katule JSC in our decision in Kizza Besigye versus Museveni, for the view that the charge of bribery had to be proved beyond reasonable doubt and not on the basis of a balance of probabilities. Counsel concluded that the evidence adduced by the respondent did not establish the allegations of bribery or charge of bribery beyond reasonable doubt. Regarding the Court of Appeal, Mr. Balifudende asserted that in the lead judgment, which other members of the panel concurred, Yambisha J.A. properly directed herself to the duty of the First Appellate Court and that she properly evaluated evidence before she applied the findings of the trial, upheld the findings of the trial judge. Then their lordship says, I am not persuaded by the argument of learned counsel for the appellant finding. First of all, the learned judge properly directed himself when, after referring to section 61(1) of the PEA, now it is the 81. He stated at paragraph 6 of the judgment, I will not read it, my lord. Then he goes on, the Justice of the Supreme Court goes on this point, I am surprised by the assertions of learned counsel for the appellant, who unfairly criticized the two courts that they misdirected themselves on the standard of proof by applying the standard sanctioned by the statute, which is balance of probabilities. Learned counsel is certainly aware of the existence of 61(3), now it is 83, for he alludes to it at the end of his arguments. Throughout his submissions, appellant counsel relied on the opinion of my learned brother, Katule JSC, in Kizza Besigye election petition, notwithstanding that the Presidential Election Petition the Presidential Elections Act does not in itself have a provision similar to 61(3) of the PEA, which clearly describes the standard of proof in parliamentary election matters. What the Supreme Court saying goes slow. I am not saying that you may not cherry pick from those decisions. Don't all summary apply, like Mr. Bagenda was doing. Let me also give you two other decisions, my lord, where the Court of Appeal is warning. It's their way of the decisions, but they warned themselves. Go slow. Now it's the decision of Muyu. Noting my lord is at page 280. It's in volume 1. 280 to 281. That's what I want to say here. This is what the Court of Appeal say. They are dealing with bribery. And they say, after quoting the decision of the land trial judge, they say, in reaching the above conclusion, the land trial judge was relying on two decisions which I have already cited. The said decisions were inapplicable because one was dealing with a petition under the Presidential Elections Act, which did not have a statutory standard of proof, and the other was determined before the enactment of the PEA. Their lordships then say the two decisions were inapplicable to the instant appeal. My lord, there is also the decision of Aligawesa on corroboration. Corroboration, I'll just give you the page, my lord, if you require the decisions at page 1467, 1468. My lord, they actually quoted the decision of the Supreme Court in Besigye versus Museveni, and then said, yes, we are alive to that, but in parliamentary elections, it is not essential. So, my lord, as we look at this in 7, my whole point is don't import. It is not the Bible or Quran for parliamentary election petitions. No. Let it stay in the presidential elections. You can cherry pick, but it is not. you don't have right call Sunday. My Lord, my learned friend Mr. Bagenda went on to point out certain portions of the law that he asserted have been settled by those decisions, and therefore for us down here we should have nothing to say. First, the issue on hearsay. Hearsay, my Lord, he went about explaining the decision of Odochi CJ in basic 301. Told us why we can't give hearsay, why affidavits should be expanded, why all those things. My Lord, the decision of Odochi CJ in that decision on the issue of affidavits and hearsay is a dissenting judgment on that matter. It is a dissenting judgment. On the issue of affidavits and hearsay, the decision of Odoki J is a dissenting judgment. My Lord, majority can be in the outcome. It can also be on a particular issue. And I'll give you another example afterwards of the Supreme Court. The lordships may agree at the outcome. Everybody can reach the decision for their different reasons. My Lord, on the issue of hearsay, the majority decision in Vestige 1 was of Sepoko, it was of Mulenga, and Karukwa. When Odochi went into explaining how evidence here, that is dissenting. And my Lord, the Court of Appeal had the opportunity to say what I'm saying. The majority say, my Lord, that if you bring the source of information, if a petitioner or respondent avers something and then brings that person who informed him, it ceases to be hearsay. Are you there? No. I know it has surprised you. No. Hey! If we ask the question, I know it has surprised them, my Lord. My Lord, in the decision of Mpanga Farouk, I am no, my Lord. I have the excerpts in the decision I'm going to refer to. They quoted the decision of Odochi, Karokora, Mulenga, and they told you that on this one already was dissenting. This decision I'm referring to. And it quoted all of those excerpts. So again, I don't have page numbers, so I can't refer to this. Decision is in Mpanga Farouk. No, this one is a new case, my Lord. Mpanga Farouk versus Senkubuge Isaac. Mpanga Farouk versus Senkubuge Isaac. Court of Appeal decision. Election Petition Appeal number 13 of 2021.